Well, good morning, everyone, and thank you for joining us for this second in a series of four seminars having to do with reporting and sources and public records and data. And I'm John Ferrugia. I'm with the Colorado News Collaborative, CoLab, and Jeff Roberts from the FOIC will be with us this morning, the CFOIC, who is a public records expert. And we're naming this today, Your Right to Public Records and How to Get Them. And you can see right here that Jeff Roberts is the executive director of the Colorado Freedom of Information Coalition, former Denver Post reporter and editor, data journalism specialist. He's an educator, he's a public records expert, and you can read all about him at that link if you'd like. And also I put a link up for myself as well, so you can see what I do for a living. So I think we should start with just the idea that your right to public records really is about your daily reporting. They're the underlying support for facts, for context, for understanding. I think we all know that. And it's really about transparency, holding the government accountable for its actions and its spending. And if you think about public records, you're really thinking about a window into every government action or inaction affecting its citizens. And public records are simply essential to a functioning democratic republic. So I wanted to start with an example this morning to give you an idea of just how essential public records are to our daily reporting. And this is any story that you're doing, any story that you might be doing on a daily basis, and it's really a mindset about thinking, okay, well, wait a minute, is there a public record that can give me more information about that? I've got this daily story today, but if I put in this open records request, maybe it will lead to other stories, and it may lead to something greater than I first thought about. So this is an example of that. This is the detention center in Aurora, Colorado. It holds detainees, immigrant detainees. It also, the federal marshals have a contract to hold some convicted felons before their sentencing. Now, there's a private federal contractor that runs this operation, and no journalists, no cameras are allowed in this place. Now, we had heard that there were crimes against detainees that were not being addressed or investigated. But how do you get at an issue if we can't get inside this facility and no one's going to talk to us from the contractor or from Homeland Security or the federal marshals? Well, the answer, obviously, is public records. What can we get to take us behind these walls to figure out what's going on? And this is the story of how we use public records to get behind the walls.
911, what is the address of the emergency?
A lot of what happens inside this detention center is secret. But the calls for help that come from inside are not.
I'm calling from the Aurora ICE Processing Center.
So we decided to start listening.
Usually they just give us an incident number.
We gathered 911 recordings from the facility and began to hear something that just didn't seem right.
911, are you reporting a life-threatening emergency?
Yes.
What happened?
Okay, the gentleman got beat up really bad. He has a head injury.
In this call, a nurse wants an ambulance for a detainee beaten by a group of inmates. It happened 3 hours earlier.
That happened around 1500,
Right.
Or 3 hours ago?
1500, yep.
An ambulance rushes that detainee to the hospital, and an Aurora police officer comes to the detention center to investigate.
And you just saw him like stomping on him?
You can say a lot of them were just, people were just running up into him and stomping on him.
This is video from the officer's body camera.
Somebody's always got to be beefing and acting a fool.
The man they're talking about is Lawrence Ritchie.
His nose was broke, both of his eyes were blackened.
Tracy Bates is Ritchie's sister.
The eyelid was torn in half, all his ribs were broken.
Ritchie was being held in the Aurora Detention Facility in the custody of the U.S. Marshal Service. The Marshals have a contract with GO to hold up to 320 federal criminal defendants in a separate housing unit from immigration detainees. And the Marshals have a policy that criminal allegations in detention centers should be referred to the appropriate criminal justice agency. But Aurora Police did not investigate the Ritchie case.
So then I won't talk to him. I will make a report.
Okay.
And in my report, I'll say you guys want to handle it in-house unless you need our assistance in the future.
Okay.
This Aurora police officer wrote in her report that GO security staff asked her not to talk to Lawrence Ritchie because the investigation would be handled internally.
If he decides to press charges and he wants to call the local police in the area,
Okay.
then we will do that.
Okay.
And then,
So
these
wait
guys,
for now.
Yeah, these guys
Okay.
are all pending. The marshal guys are all pending going to prison.
Okay, so they're probably not even worried about it anyways.
Yeah.
Doesn't matter if they're going to prison or not, they're still a human being. Somebody should have been held accountable. You can't just go around, 5, 6, 7 men beating up on one person.
Law enforcement needs to be investigating that case. It is something where there's video, there is ample evidence. I mean, we've got a situation where Geo is downplaying what has happened and Aurora is accepting that.
John Walsh was Colorado's U.S. attorney for 6 years, through 2016. The state's former head federal prosecutor reviewed the cases Insight gathered from Aurora police records, including Lawrence Ritchie's beating.
When you have someone who has been so seriously injured that they end up in the hospital, you've got to be able to go after that case for the protection not only of that victim, but of everyone else in the facility.
In October of 2018, Aurora Police and the GEO Group signed an agreement requiring GEO to refer all criminal allegations to APD so police can investigate. And here's how ICE's acting field office director responded when we asked how crimes are handled in the facility.
Criminal allegations are referred to the police. We work closely with Aurora PD when we can. They are able to come into this facility to investigate any crimes that they deem necessary to investigate.
But we found Lawrence Ritchie's case was just one in a pattern.
Direct communication. I work over at the GEO ICE detention facility.
In this call, a GEO staff member mentions a complaint of inappropriate touching made by a detainee against another staff member.
I was just calling it in and getting an incident number. We don't need anybody to dispatch.
All right, so you want me to put in a call and then just cancel it?
Yes.
So you want me to put in a call but then cancel it. That just jumps out to the ear. Okay, we're just checking a box here. We're not actually following through with the kind of criminal investigation that should be taking place.
Insight reviewed 17 calls to police about allegations of sexual abuse or misconduct inside the Aurora detention facility going back to February of 2017. Records indicate that most involved immigration detainees, and many of the calls went something like this.
We're going to do this investigation in-house.
Usually they just give us an incident number and we do the investigation.
I just need to get an incident number, but I don't need anybody to respond.
Police reports indicate that out of the 17 cases we reviewed, Aurora officers never interviewed any of the alleged victims.
So, as you saw in that particular piece, that particular story, we had no information on the record except the kind of requisite interview from the warden, essentially, of the facility, and he just gave us the standard response that everything's investigated. So what did we do in order to tell the story? What did we get? We got first the 911 calls. We got the body camera video and audio. We got Aurora police reports. We got lists and descriptions of the 17 calls in that database. All these are public records. We got the GEO contractor agreement with the federal marshals, which is also a public record. We also got the Aurora Police and GEO contractor agreement on the investigation of crimes, which was a public record. And we then matched the police reports with the 911 calls and the body camera video. So essentially, we told this entire story through public records. And a lot changed as a result of this. But again, if you walk through each one of these steps, these were just individual steps that if you're doing a daily story, you can get 911 calls on something that you did 2 weeks ago, or body cam video, and we see that all the time of a month ago. There are police reports, and don't forget that you can always get agreements between agencies if you need those. Those are all public records. So again, this is just an example of how we had a story which we couldn't tell except through public records. So if I don't know why this is not, here we go. Any questions on this? All right, so we're going to move on. And I'm going to introduce to you Jeff Roberts, who is with the CFOIC. What are you entitled to? How do you get them? Jeff knows exactly how to do this. He's been doing it for years. CFOIC is a nonprofit that can help you at no cost. It can help you. You can connect with Jeff, but he's also got legal resources that he can help you with a lawyer who can give you legal advice through CFOIC. You really need to know what your rights are, what laws apply to government custodians who can't refuse you. what records are available, who holds those records, how do you get those records? That's what this is about. So Jeff, off to you.
Okay. So as John said, I'm the executive director of the Colorado Freedom of Information Coalition, and our main purpose is to educate both journalists and the general public about their rights under Colorado's open government laws. So you probably know something about these laws already. We don't really focus too much on the Federal Freedom of Information Act, which covers state agencies, but very much so on Colorado's two public records laws, the CORA and the Criminal Justice Records Law, and the Open Meetings Law, and also the rules governing court access and court records and the administrative records of the courts. And they have different presumptions of access. So the one that covers really every state agency and local government at every level is the Colorado Open Records Act, or the CORA. We use CORA as a noun and a verb. You CORA for records. CORA covers everything except police agencies, and I'll get into that in a moment. But there's a very broad declaration. Can you go back a second, John? A very broad declaration.
I'm sorry, I'm sorry, I can't.
Okay.
Can't get back.
So a very broad declaration of access at the very beginning of CORA. It entitles you to inspect any records of state or local government, unless there's an exception, either an exception that permits the agency to withhold records or requires the agency to withhold records. And that could be elsewhere in state law, or it could be in a court decision. So what is a public record? A public record could be really anything that the government entity holds, makes, maintains, or keeps. And that could be a piece of paper, less likely that it's that these days, more likely it's a digital record. It could be an email, it could be an audio, and it could be a video, which is something that you're probably very interested in obtaining. And it really just has to involve the exercise of governmental functions, or involve the receipt or expenditure of public funds. Pretty much everything. You can go on to the next one, John. So you may hear stories about the federal FOIA and reporters waiting months or sometimes years to get records. CORA has a much quicker response time, at least what's said in the law. And it really involves records that are not readily available. So if the government entity has something like a board packet, for instance, that you know has been prepared and has already been passed out to board members, that's readily available. That's something you should be able to get right now. Otherwise, the time for response, the time to produce the records, is supposed to be 3 working days or less. So pretty short period of time. And then if it's a big request, or there's some other extenuating circumstances, during COVID, some governments have used that as an excuse for extenuating circumstances. They can extend that by another 7 working days. The problem with this is that there's not a lot of teeth in the law to enforce this. So sometimes you just have to work with them and keep bugging them. There is, in Colorado, often a cost to obtain public records. This isn't the case in every state, but government entities can charge for what's called research and retrieval. So that is finding the records, going over them to make sure there is nothing that either can't be released or that they're allowed to withhold, and then perhaps redacting certain information. And so the state law caps the hourly rate that they can charge you at up to $33.58 an hour. That's reset every 5 years for depending on the inflation rate. One thing to note is they can't charge you anything unless they have a fee policy that has been published in some form, usually on their website. Occasionally, we find some, usually a smaller government, that is neglected to do that. And you can hold them, say, hey, you can't charge me anything for this. The cost of obtaining public records is a problem in Colorado, and it's one we're trying to work on with the press and the Broadcasters Association to change. The issue is that this hourly rate is capped, but there's nothing that really can stop an agency from saying that's going to be 10, 20, 40, 50 hours worth of work. And you as the requester don't necessarily know if it's really going to take that long, or if you're paying for their messiness and the way they keep their records. So particularly for things like when you request emails, it can become a very expensive proposition. Some news organizations occasionally will tell their readers or viewers what it took to obtain public records, the cost. Here's a story from Colorado Politics early on in the pandemic about what this news organization had to pay to get some pretty basic records to be able to explain something to the public. It's a good idea to let your audience know sometimes that this is an issue. There are some strategies for trying to reduce the cost of KORAs. It's a little frustrating still, but what you really want to do is set some parameters if you can, date parameters, search terms, things like that help you narrow the scope of your request, being as specific as you can, so that it's easier for the records custodian to find the records. And if it's easier for them to find the records, then it'll be less expensive for you. And they're not allowed to charge for that first hour of what's called research and retrieval. So if you can point them to something you really know you want, theoretically, sometimes it shouldn't cost you anything. Sometimes, there's other ways at it. Sometimes an elected official can make a request for you. I've seen people crowdfund requests, news organizations sometimes working together if they all want the same thing. And then you want to ask for some kind of itemized invoice explaining what's really required to retrieve the records. This is not something they're required to give you, but I think it's a reasonable thing. Maybe that's something we can get changed in the law.
Any questions, anyone? All right, we'll move on.
Okay, so as I said before, KORA allows records custodians to withhold certain records, and then it requires other records that must be withheld. So there's two sections within the law itself. There are some discretionary denials where a records custodian can withhold some records if they determine that disclosure would be, quote, contrary to the public interest. So it could be things like details of a research project at CU, or if some constituent provides email addresses, things like that. They're hard to challenge, but you can argue against these things sometimes. One of them was put in after 9/11. This is details of security procedures. Recently, they added cyber assets of critical infrastructure. And occasionally these things are, I think, abused. John, if you go to the next slide, I'll show an example of that. This is a story that the Daily Camera did a few years ago. They were actually just doing a feature on Ralphie the Buffalo, the mascot at CU. And the reporter asked for some records about where they keep Ralphie when Ralphie's not being used during CU football games. And CU actually cited this post 9/11 provision in KORA to withhold records about the whereabouts of Ralphie the Buffalo. It wasn't something worth fighting. It was just more laughable and an example of how sometimes these provisions can be kind of exploited, I think. Then there's this section in Cora of records that must be withheld. But you need to know something sometimes about how courts have interpreted these mandatory denials. So some of them are pretty clear cut and sometimes frustrating. You can be denied, say you're looking into some allegation against a public official, and you get the response that the records cannot be disclosed because they involve a sexual harassment complaint. Well, you're not going to get the records, but that still may be a clue as to what actually is going on when you report your story. Maybe there's another way into it. If you go to the next slide, John, personnel files is another example where they say that Cora says you can't have certain records about public employees. Next slide is a little bit more detailed about this. I guess we already had. It's on a slide after that. I was going to talk a little bit. I'll hold off on personnel files. There it is.
We can go. Does anybody have any question that they want to ask along the way here?
Hi, Jeff.
Okay.
Yeah. Hi,
John. It's Katie Pelton with KKTV 11 News. I'm sorry for joining a little late here. Thank you so much for holding this. I did have questions about personnel records. I know that you were saying, just in the last couple of years that there have been some changes to that with Cora and that we are able to request some personnel records now, right?
Actually, it's more involving the court rulings that give you. Cora hasn't changed in that regard. And actually, some court rulings have been around for a while, but it's really something that you should know about how the courts have interpreted this. So Cora will say that you're not entitled to personnel files, but how the courts have looked at that in Colorado is that you're really only talking about what they call personal demographic information of the public employee. So their home address, their home telephone number, their personal financial information. It is not information about their performance on the job. So if you might remember a story that KKTV did last spring involving a school bus driver who slapped a student across the face for not wearing a mask properly. So the reporter contacted us because she had been denied the surveillance video from the bus, which was very important to show actually what had happened in this incident. And the school district denied it based on the federal education privacy law and this personnel files exception in Cora. And so our board president, Steve Zansberg, who's a lawyer who specializes in these laws and represents media, he wrote a letter to the school district saying, no, for one thing, courts around the country have said that FERPA doesn't apply when you're talking about disciplinary records or uses of disciplinary actions against employees, and you can also blur the faces of the students. And then personnel files, there has been a court decision specifically, it's a lower court decision, but it's specifically about the disciplinary records of school bus drivers. So the district actually released this video after the letter from Steve Zansberg with the student's face blurred, but it showed what happened, and it was very powerful for the story.
Another thing I would add as well is that when you talk about personnel records, a person's application for employment is not covered under this. And I have many times looked for an individual who works for a public entity and asked for their application. Now, you can't get their social security number, obviously, or things like that, but there is a lot of information in the application which is relevant to what the person's done in the past, to whether their education, for instance, if their qualifications, whether they've maybe fudged on their education or their qualifications or their job performance, et cetera. It gives you an inroad into their past employment, where you can actually look at those disciplinary records and find out if someone was hired and passed along a bad employee. So the job application records are also very, very useful in
Right.
in looking at employees.
And that's for current and former employees. So I'll always keep that in mind. Also, any pay information, any salary information is a public record. So there are exceptions to that sort of blanket, what appears to be kind of a blanket exception in CORA. This is from the URA paper. The paper wanted the personnel files of 2 employees who were disciplined for working too much during the pandemic. That's actually what they were disciplined for. And the county at first denied these. The county actually took the reporter to court to get a ruling about this, and the newspaper won, and actually it was settled because the employees came forward with their own records. So these, if you ever get in that situation and you're denied personnel files, contact us, because we very often can help with that. Another very frequently requested public record are emails, text messages. This may be the most requested public record these days, because requesting or getting emails gives you a good sense of what is happening within government, kind of behind the scenes. If people won't talk about something that's going on in government, sometimes their internal communications are very interesting to obtain. And so what you need to know about requesting emails and text messages is it's the content of the message that determines whether it's a public record or not. So even if it is on a private account, so a private phone or a personal email account, if it involves public business, then it is very likely a public record. So we have state legislators using personal accounts to conduct public business, and in a lot of governments, people who are elected officials use personal accounts. There's been one sort of higher court decision, a Colorado Supreme Court ruling about this issue. Happened several years ago in Arapahoe County. Some of you may remember this, where the former Arapahoe County clerk, or the clerk at the time, was having an affair with his deputy, and the Denver Post and the Rocky Mountain News, so that tells you how long ago this was, were interested in the communications between the two of them. And the Colorado Supreme Court eventually ruled that the newspapers could have any communications that dealt with public business. So, the county clerk's budget, for instance, something like that, but nothing about their affair. So it really has to do with public business. That's what it comes down to.
Any questions there? All right, move on.
Katie again with KKTV. I'm sorry.
Yeah. That's good.
Wasn't there a recent, or not recent, but several years ago, Jeff, where there was an instance down in Denver where they did end up giving away private text messages? And I can't remember what the story was in regards to, but it was some public official, and I thought it was a somewhat private matter, but they ruled that since he was a public official, that he did have to turn over some of his text messages.
I'm not remembering what specifically that
Okay.
one was, but it really has to deal with, government business in order for it to be considered subject to quorum.
Okay. I thought it was some sort of like headline, like grabbing story, but I'll have to think about it.
Yeah,
Okay,
yeah. If
thank
you
you.
remember what it is, bring it up. Bring it up later.
Okay.
Another thing to know, settlement agreements between a government entity and whomever. These cannot be, it can't contract their way around the open records law. They can't write into the settlement agreement that the public can't know about some sort of agreement between the entity and whomever, where public money is involved, that type of thing. So occasionally you get these denials, and if that happens, let us know, because there are plenty of court rulings to say that settlement agreements between a government entity and another party are public records.
And just an add here, if you're interested in this, it's very important to ask for this periodically, especially if you're in a rural county, because nothing says that the agreement has to be announced publicly. So if you periodically ask for all settlements or expenditures, you're going to find occasionally, all of a sudden, you're going to find this big settlement that's come out, a $300,000 settlement or whatever, and you're going to then track it down and figure out what it is. Because a lot of counties might do this, like for sexual harassment or an accident or a dump truck that hit someone or whatever. They'll have a huge settlement that you will not know anything about because it's never been publicized. But unless you ask for it, you will never know. So periodically, at least once a year, every reporter should be asking the local entities, county, municipal, whatever, for any expenditures, any settlements that are on the record.
Yeah, some of these bigger settlements should be coming up before their city councils, but that doesn't always happen.
And they try to do it sometimes in executive session, which you're going to get to later, but they try to hide it.
Right, and I think it was the Gazette several years ago did stories about the Colorado Springs City Council never bringing these things up before the public and deciding them behind closed doors.
Yeah.
And a reporter there did exactly what John just said, requested a year's or 2 years worth of settlement agreements and found millions of dollars being approved behind closed doors. And they eventually changed their policy over that. So autopsy reports, you might think of an autopsy report as being a criminal justice record, but it's actually a Colorado Open Records Act record. And that's important because it's much easier to obtain completed autopsy reports because they are Cora records. And I'll talk in a few minutes about criminal justice records and how there's a different presumption of openness. But if you get denied an autopsy report and you know that the autopsy report has been completed, let us know about that as well, because we have successfully fought these for many years.
And I would also add here that autopsy reports are a good source of information about public institutions where people are held, like mental health institutions or jails or hospitals, public hospitals. Because, for instance, if you look at the mental health center in Pueblo, the state's largest mental health center, we looked at autopsy reports in that county and found a number of people who died at that facility that we were not aware of in the address of that facility. And what we found is in some cases, people were over medicated, et cetera, and died of things that it was not criminal, at least at the time, but died of errors. So autopsy reports, especially in counties where you have public hospitals, public facilities, mental health facilities, et cetera, it's a good idea to check once a year and just see what autopsies have been done on people from those particular addresses, those particular entities.
So a law that we helped get passed a few years ago now entitles you to public records, Cora records at least, in their native format. So if public records are kept in a spreadsheet, you're entitled to them in that format. And you may want to do some analysis on those records. If there's hundreds or thousands of records, they can't just give you a PDF or a printout of that. Now that this law has been on the books since 2017. So that's really important. Recently did something on my blog about a woman who requested records from a charter school in Monument, and she specifically asked for digital copies, and she was given this box full of paper that had been left out in the rain. And we got a lawyer to help her, and she not only got her money back, but she got the digital records.
And another thing I would add here that's really important is that fourth bullet point there. Public officials will often say to you, well, we don't have to alter and make a new record if we delete the Social Security field in our record, in our digital record, then that constitutes a new a record, and we don't have to, we're not required by law to actually create that new record. Well, that doesn't under this law. That's very important because
right.
you can excise different fields of privacy, like a address, home address, and a social security number, and they still have to give it to you. But they still believe, many public officials, especially in rural counties and in some, well, in Colorado Springs, this came up as well with me, that, well, we don't have to create that record. Yes, you do, because excising a record, taking out a field does not constitute creating a new record.
So,
may I ask a question about that?
Please do.
Yeah. When I have Cora'd to get, here in Colorado Springs, previously they had let go of their fire chief years ago, and I was trying to find out why, and I Cora'd all their correspondence back and forth between each other because they wouldn't tell us why.
Mhm.
Now they gave me all of the, they ended up giving me emails. I believe it was on like a CD or like a DVD.
Mhm.
Now, does this change things? Like, would they have to send them digitally now, or does that affect it at all? Are they still able to do that where they give it to you on like a DVD of all the records?
Did they give you a PDF, a searchable PDF?
No, not at that time, but this was years ago.
So, if they gave you, say, the Outlook export, that would be okay. You
Okay.
could import it into Outlook. If they gave you a searchable PDF, that would be okay. If they gave you a static PDF where you couldn't search it, does not fit with the new law.
Okay, that's good to know.
Because
I
they're
think that's what
they're
it was.
If the records
they're
are,
actually
if the records are originally searchable, they have to give them to you in a searchable format. Same thing if
they're
they're
actually
sortable,
creating
they have to give them to you in a sortable format.
I'm sorry, that's actually, they're actually creating a new record in order to keep you from searching the records. That's what they're doing. And
Okay.
yeah.
Thank you so much.
So, that's another thing to let us know about. If they give you something that you can't search, that doesn't fit. It's like that box full of rain soaked paper.
Okay.
So challenging a denial of access under Cora. Some states have some sort of administrative appeal process. Colorado does not have that. So your recourse, if you've tried you've contacted CFOIC, maybe we've gotten a lawyer to try to help you, and you're still, it's a denial that we all think is inappropriate. The government entity is standing their ground. Going to court may be the recourse, and that's that's how you actually would fight a denial of access in Colorado. That's the remedy in the law for doing so. So there is a process for that. You have to file a notice of intent to sue. If you don't make an argument that the records are needed right away, it's 14 days. And during that time, the records custodian is supposed to have a conversation with you to try to work it out. And if that doesn't happen, then you go forward with the lawsuit. The one good thing about this, it's an intimidating thing to do, but if you prevail, it's required that your court costs and attorney's fees get awarded. Really important, writing the Cora letter. You don't always have to use Cora. You can just ask for records, especially if there's something really specific that you want. But the reason to use the Open Records Act is, number one, it starts a clock. There's those 3 working days that they have to respond to you, or ask for another 7 if it's extenuating circumstances. And they are required to respond to a Cora. So those are reasons to actually use the law. We have this template on our website, which I'll show you at the end of the presentation, for writing a Cora letter. It also covers criminal justice records, but really important aspects of this. Be as detailed as you can. You want to help them find the records that you want. That limits your cost. Sometimes you don't necessarily know exactly what you want. They might call it a fishing expedition. We think fishing expeditions are okay, but just keep in mind that it could be an expensive fishing expedition. You want to ask for records, not information. You want to ask for records that show information. So you're not asking them questions, you're asking for actual records that exist. And then you want a cost estimate, so you're not shocked when they tell you it's going to be hundreds or sometimes thousands of dollars. And also really important, and you should ask for this up front, if they're going to deny you any or part of the records you've requested. So if they redact something, for instance, you want a citation of the statute that authorizes that withholding. You're entitled to that under the law.
Any questions here?
No, just a comment that's happened to me many times where they've said, "Oh, let's give her a high bill and we won't have to deal with this, Cora." I know
It's called a called a chilling effect, right?
Yeah.
And that's why we think that we need to adjust the law in Colorado, because it does have a chilling effect when you get that estimate of so much money. Sometimes you are able to reduce the cost by, you want to talk with the records custodian and see if there's a way you can reframe it or something and still get something useful for you. But we think that there's got to be a better way to set it up than it is now. So the other public records law is the Colorado Criminal Justice Records Act. And so CORA covers all of the records of state and local governments in Colorado, except for law enforcement records. And those are covered by CCJRA, the Colorado Criminal Justice Records Act. There is a very different presumption of openness in CCJRA than there is in CORA. With CORA, you can presume that the records that you want are open unless there's something in the law or elsewhere in the law that either says they can withhold them or they have to withhold them. Under CCJRA, there's only a few categories of records now that must be produced. So, and there's a couple of new categories just the last few years that have opened things up a bit, but it still can be very difficult. So records of official action must be provided to you, but that's really just kind of basic arrest reports. So the arrest report that shows, somebody's been arrested and what the charge is, but it's not the arrest affidavit, which is the record that you really want, which is that detailed explanation of why someone has been arrested. Those can be withheld upon a finding that disclosure would be, quote, contrary to the public interest. So you make a request and you get that denial, and it can be pretty frustrating. What the agency, when they make that determination, is supposed to do is balance certain interests. So the privacy of individuals mentioned in the records. Very common is the agency's interest in their ongoing investigation, and then the public interest. They're supposed to consider that as well. This is from a court decision after Columbine. And what you need to do if you get that denial is just keep asking. So as an investigation is ongoing, as that winds down, that factor becomes less important in this balancing test, and the public interest grows as a factor that they have to consider when deciding whether to release these records or not. And then the other thing, there's another court decision that basically says one of the important things it says is that they should use redaction as a tool to release as much information as they can from criminal justice records while protecting privacy interests. So if you know something about these court rulings, you can kind of put them in your responses when you get these denials, and keep bringing them up because you're going to want to you hopefully will get the records you want eventually.
May I say something about CCJRAs?
Yes.
I don't know if it's the same in Denver, but I mean, anytime we file them here, we are denied. It's very rare that we get anything, and they always just say it's still under investigation and we don't have to release anything yet. And it seems like it just is ongoing. It's never released.
Yeah. So one of the things that we'd like to see changed in the law is a time of response in CCJRA, like in CORA. The only time of response in CCJRA is for records of official action. So this basic arrest report that you see on a screen, you can have that within 3 days, but that doesn't tell you a whole lot. There's no specific time of response for all these other criminal justice records that they can just withhold as contrary to the public interest. So you're right. They could say the investigation is ongoing for years potentially, and that is very frustrating. You keep asking, you keep bugging them, you keep pointing out what the public interest is in getting these records, but they can do that. This happened. This was pretty frequent with requests for body cam footage until this new law that was recently passed, and I'll get into that in a second.
Yeah. So this is arrest records. Have we covered this, Jeff?
Yeah, we've recovered this. This is just that really basic information in the record of official action. So a couple of areas that, a couple of very positive developments regarding criminal justice records in Colorado over the past few years. This is a law that we worked on. We worked with the ACLU and got University of Denver to do a study about internal affairs records, police internal affairs records. And just about every police agency in Colorado routinely denied requests for these records, except for Denver. Denver started providing these records about 10 years ago or so after getting sued many, many times. And they just made it their policy that they would provide these records. Now, after this 2019 law, every law enforcement agency in Colorado must provide records of completed internal affairs investigations. However, it's really only records related to an incident of alleged misconduct involving a member of the public while an officer is in uniform or on duty. So the loophole here are, an officer who gets drunk on the job, and I'm thinking of a specific story from a few years ago, and may not have, I think there was an officer who was found asleep in his car, because he was drunk on the job. he wasn't interacting with the public. So technically, that's not an IA report that you're entitled to under this law. It's kind of the loophole of it, but it does cover a lot of these records. There was another loophole that was just closed, where a lot of agencies, and I believe Colorado Springs and El Paso County were doing this. They were making you identify the incident, be really specific. You had to know something had happened in order to request these records. And the legislature fixed that last session, and also there was a Colorado Supreme Court ruling about that. So now you can ask for completed internal affairs records. You ask for these once a month or something like that. Denver provides these to reporters monthly, and it's pretty interesting information sometimes.
Wow, yeah, that's incredible. I bet there's a lot of good stories in those.
Yeah, there's a lot of great stories on that, and you're now entitled to records that used to be really hard to get. Another really positive development are body cam and dash cam footage, and so this just went into effect last year, where you are now entitled to body cam and dash cam footage. Again, it has to involve a complaint of officer misconduct. But there's, it has to be released no later than 21 days after the complaint is made. If it's still under investigation, they have until 45 days. And if the officer has been charged with something, then the officer can go to court and object to the release of this. This has happened at least twice that I know of since the law went into effect. A Greeley officer and a Sheridan officer, but in both cases, the judge denied their request to keep the body cam footage secret. So those were released, and news media got it. So ask for that stuff as well. Jail logs are a really good constant source of just knowing who is in the jail. This is a law that's been on the books for 100 years. And always keep that in mind if you're wondering if somebody has been arrested and the police aren't giving you any kind of arrest record yet, always check the jail log. So there's a cost to criminal justice records, just like in CORA. It's different. Although a lot of agencies use the same per hour rate as in CORA, but they're really not supposed to charge any more than their actual costs. And so if you know that for body cam footage, for instance, if you know that multiple news organizations want the same thing you want, you can just have one of them pay this, and then you can share the cost. Challenging denials, it's a different standard, but you also have to go to court to do this. And there's a different standard for actually getting records released under CCJRA. If you go to court, you have to show that the agency abused their discretion, and it's very difficult to show that. Juvenile justice records, you probably also know something about this. Very difficult to obtain information on a juvenile charged with crime unless they're charged in adult court. You can get the information, you just can't get the identity of the juvenile unless they're charged in adult court.
Any other questions on this?
No, thank you.
And we go to open meetings.
Yeah, let's run through this kind of quickly. Sort of the third leg of the stool of open government laws in Colorado is the open meetings law, which is also known as the Sunshine Law. There's a very powerful declaration at the beginning of this law. It's declared to be the policy of this state that the formation of public policy is public business and may not be conducted in secret. So, what is an open meeting? It's not just necessarily that school board meeting or that city council meeting that you know is scheduled and going on. A meeting can be defined as something electronic. So these days, of course, we have meetings held by Zoom, things like that, or WebEx. But if a public body, if 3 or more members of a local public body, like a school board or a city council, if they communicate by email or text message, that too is a meeting covered by the law, but it's a meeting that the public can't attend. So,
Jeff, is that two? That's two or more, right? So
for a state public body like the legislature, it's 2 or more. For a local public body, it's 3 or more, or a quorum, whichever is fewer. So this is where this very likely happens a whole lot more than anyone ever gets caught doing it, because you would have to Cora for the records. And this is something the Pueblo Chieftain did this many years ago, where they Cora'd for email communications among council members and found 3 members of the council conducting public business by email. And that was a violation of the open meetings law, because it was a meeting that the public didn't know anything about and couldn't attend. And they did several stories about the content of those emails. But if you suspect this is happening, a Cora is a way into that. But it's really it's something that I believe is probably abused a lot. So really, the meetings have to concern public business, and there has been a higher court ruling that says the meeting has to pertain to that public body's policy-making function to be open to the public. Full and timely notice to the public has to precede the meeting by at least 24 hours. There's not a lot of detail in the law about what that means, how detailed the notice is supposed to be. Same thing goes for minutes. There's, just says that minutes must be taken, but there's not a whole lot in there about how detailed the minutes have to be. Often, you want to try to get audio or video if you can. So very important in the open meetings law are executive sessions. This is where a public body can be authorized, or the law authorizes a public body to close the door on the public and journalists for certain subject matter. So there's a process for doing this that they must go through. They must announce it to the public in as much detail as possible, what the subject matter of the closed door meeting is going to be, without ruining the point of closing the door. And they have to take a vote of doing this. And there's been court decisions about this, and you can catch a public body for violating the open meetings law sometimes, for not going through this process like they're supposed to. In an executive session, they're really for the discussion. It's really for discussion and deliberation. They're not supposed to public body is not supposed to make decisions in the executive sessions. So common violations of the Sunshine Law, making decisions in executive session. We hear about that fairly often, where an executive session will happen, public body comes out and immediately votes on something. And you wonder, well, how did that happen? They didn't discuss it in public. And so we hear about that type of thing. The way to challenge a violation of the open meetings law is the same way you would challenge a violation of Cora or CCJRA. You have to go to court. And so a judge would be looking at an executive session recording and listening to that to see if they strayed from the authorized topics, or, did they announce the executive session properly? That type of thing. There's not a lot of teeth in the law. You could have the release of an executive session recording or portions of that. That's happened. But a judge might say, we found that you did this, don't do it again, that type of thing. And then the person bringing the lawsuit would get their attorney's fees and their court costs.
Any questions on the Sunshine Law? All right. Jeff, thanks very much for that.
Yeah.
I think the important thing here is that all of this information is now on this video recording. So if you're getting ready to do a core request or Criminal Justice Records Act request, you can go back to one of these slides, and if you're being denied or you need some backup to say, hey, look, there's a ruling and the court's made this ruling, and here's why I'm asking for this, and you can't deny it under this because there's been a court ruling. It's very helpful to have this information in front of you where you can make notes or you can reference it. So that's a really, really important aspect of this. So I want to let you know that this presentation is going to remain online at the CBA member website. We're really here to help you. Jeff's contact number is right there, his contact email. My contact email at CoLab is here. Want you to know that all of these conversations with us are proprietary and confidential. So if you're working on a story and you call me or you call Jeff or you email us and say, hey, look, I'm working on this, I need some help. We're not going to be talking about your story or your CORA or your records request or Sunshine Law, whatever, with anyone else. This is all proprietary and confidential. So, that's why we're doing this. We want you to be able to have this resource, even if you just want to run something by us and have us say, gee, we don't know, but here's how you can find out. Or look, in Jeff's case, he's got a lawyer on call that can help, can give you a call and help you with a specific issue. So we're here to help. It's free, and thanks to Justin Sasso at the CBA for being involved in this, because he thinks it's very important for the members to be able to have access and understand what resources are out there. And especially if you're in a rural area where you're working in a very small newsroom, in a radio station or a TV station, or a digital outlet, call us if you're concerned or want some information about how things work, or we can always be a resource for you to help you find someone who can give you the answer. Any other questions?
So I'd like to take a minute and share my screen and show you all CFOIC's website. Do you want to get out of this one, John?
Sure. I'll let me just do this. I'll stop sharing my screen here. All right.
Okay. So I'm going to share my screen for just a moment. So this is coloradofoic.org, which is our website. And there's a ton of information on this. One thing that I do pretty regularly is write a blog about open government issues in Colorado. There's close to 530 articles on this that we've written about all sorts of topics that are relevant to these questions that we've talked about today. So please explore that. But the main thing I want to really point out is our Sunshine Laws Guide. So this is something that we formerly published in booklet form. And as of last November, we are now publishing online. And it is completely free for anybody to use. X out of this. And it's really everything I just talked about and a whole lot more. So you can go down here and look for, something about fees, for instance. It'll take you to the information but also you can go directly to the statute as well if you're interested in, looking to, more information about that. Or, there's a particular court case, that is relevant to the topic. It'll give you a link to that as well. So go to that Sunshine Laws guide. It's free to use. Tell your newsrooms about it, because the questions that you may have are likely, the answers to them are likely in there. But as John said, you are free to contact me whenever, and I will try to help.
And the Colorado News Collaborative, we have senior reporters there, Tina Griego, Susan Green, are also available anytime for as a resource for stories. And again, it's proprietary. If you need help, you can call us. So thank you all very much. And we're going to be doing another seminar not next month in February, because that's the February ratings period for all the broadcasters. But in March, we will be back with another reporting seminar. So thank you all very much.